Well, I wanted to take a few minutes and explain this. No, we're not filming a new commercial that you're all going to be a part of. I promise that's not what's going on. As y'all know, Texas Criminal Defense Lawyers is near and dear to my heart. It's a wonderful organization that helped me tremendously getting started as a young lawyer, and they promoted me through their ranks and at one point decided that I should be the head of it, and it has been a fabulous opportunity for me, and I love that group. They called me and said that the Court of Criminal Appeals, in their austerity program of trying to put on CLE all around the state as cheaply as possible, was insisting that they film some of their speakers. And as all you know, everybody needs ethics. TCDLA specifically asked if they could film this. So that is what this is here. And as y'all know me, you know I like to move around and be animated and loud and hysterical at times on some of this stuff. So I'm supposed to stand in one place, so I will let you know. It's going to be difficult for me, but we're going to make an effort of it. I want to welcome all of you. I do want to encourage all of you, if you are not a member of the Austin Criminal Defense Lawyers, to please join them. They do this free every Friday for you. If you're not a member of TCDLA, please join them. It is the statewide organization. It is the only voice of sanity at the legislature. We are over there constantly trying to keep them from cutting fingers off for theft cases and, as you can imagine, other things on child abuse cases. So those are things that are important to have a voice of sanity, and I ask you to consider joining. My topic is ethics, and we're going to spend the next hour going through a number of different issues. I do want to speak to you a moment about what happened to the proposed rules. As all of you know, the State Bar spent about 10 years working on some new disciplinary rules. There was a statewide vote, and it was voted down. And so, of course, the question was, where did all this opposition to the rules come from? There was the concern by the insurance defense firms that the new conflict of interest rules would require them to tell the insurance agent that they're really representing the insurance company. And so there were some big concerns by the insurance defense firms. The personal injury lawyers didn't like some of the safekeeping of property rules. The family lawyers didn't like some of the potential client rules. Could a husband come in and interview every lawyer in the county and therefore conflict them out so the wife would not have a local counsel when she went to try to get one? And so, as you know, they were resoundingly voted down by the bar. We're one of the few bars that actually has a vote by all the members on the rules, and they were voted down. And of course, the reason that a lot of us thought that it was voted down was this proposed rule. Yes, the no sex with clients rule. And my big fear was that Texas Lawyer was going to run this headline, that we want to continue screwing our clients. Yes, this was my fear. They were nice enough not to do that. They went off on a lot of different things, and the stuff that I felt like that was very, very confusing for the criminal lawyers were the issue of flat fees. If y'all were on the email list that got bombarded with the email people about how horrible the rules are, it was all that it was going to ban flat fees for criminal lawyers. The problem with that statement is the new rules didn't change the old rules. So if it banned flat fees, that means flat fees are banned now. So I needed to feel like to get some information out there that no, they would not have prohibited it, but it is an issue of how criminal lawyers charge their fees. It just simply says that unearned fees have to be returned. Well, just think about that from a public's point of view. Are we going to say that we as lawyers get to keep unearned fees? I don't think we can sell that to the public, right? That's not going to be sold to the public. So it simply said that any unearned fee has to be returned to the client. And the reason that was important is because the current rules have that in them in all of the discussions and in the case law about fees, but it wasn't very specific. So it was to try to clarify it. The other thing it would clarify is that the client money has to be kept separate from the lawyer money. This is all, everybody knows big PI lawyers have trust accounts in order to put all their big settlements in their trust account. A lot of criminal lawyers practice without a trust account. But this is the basis of flat fee issues, is that if it isn't earned, then it's the client's money until it is earned, and it has to be in a separate account from the attorneys. But the truth is, Consumer Reports has come out and advocated that all lawyers ought to go to flat fees, that it's actually better for the consumer to know what they're paying for, to know what's going to be covered. So flat fees are here, flat fees are legal, and they're going to be around, and they're absolutely approved by the state bar. So what are the issues with the trust account violation? For any of y'all that know this case, this is the case that has really caused all of us a tremendous amount of problems. It's Cluck versus the Commission for Lawyer Discipline. Whenever the state bar initiates a grievance, they do it in the name of the Commission for Lawyer Discipline. So all appeals are Cluck versus the Commission for Lawyer Discipline. In the Cluck case, he had a contract that said he had a non-refundable retainer. The problem for the case was that he billed against it. If it's a non-refundable retainer, then it is earned and it is the lawyer's money and he's not billing against it. If you bill against it, it automatically says that this was money for future services, right? For an advanced fee. And the thing that really got all of our attention, people who over the years have used the word non-refundable retainer, is that the Third Court of Appeals in Austin said, we don't care what you call it, just calling it a non-refundable retainer does not make it so. And that scared all of us to death, right? Because that had been the magic words for years. What they said that in Cluck, that it was an advanced fee, and really where they came down on upholding the grievance, because he had been sanctioned by the local grievance committee, he appealed to the Third Court of Appeals. Where they upheld the local grievance committee was solely on the fact that he did not deposit it into a trust account. Because he was billing against it, it was an advanced fee and it had to be deposited into the trust account. So, what do we learn from Cluck is that unearned fees have to be deposited into a trust account. You have to designate a trust account separate from your operating account, and the rules require that you keep the records for 5 years. So the bar can come in and say they want to see your records of your trust account for the last 5 years, and you have to keep that. So for criminal lawyers, that this is something new and maybe not something that we were really familiar with, part of what I asked them to do, and the state bar was very responsive about doing it, was getting some information online. This website is texasbar.com. You click on the lawyers link there for lawyers. It will take you to this that says trust accounts. When you click on trust accounts, you'll see there's a whole description about a new trust account booklet. This is all online and all free. This is the trust account booklet. I do not claim any owner of authorship. We had CPAs write it. They are knowledgeable, they know how to set one up, they know how to do it properly so that you won't be getting in trouble with the state bar. So if you're not going to say that your fees are earned at the time you receive them, you need a trust account to deposit it into because it's an advanced fee, and then you can pull it out of the trust account when it's earned. So this is a really, really valuable website. It's a valuable booklet. If you follow it, you will not have problems with the state bar. You will not end up in the situation that Cluck did, where the only part of the sanction that was upheld, they were fighting the reasonableness and the unconscionable and whether or not the fee should be returned. And it ends up that the court just goes off on the fact that, well, he didn't deposit it into a trust account. It was an advance fee, because he was billing against it and he didn't deposit it into a trust account. So what about flat fees? They can, in fact, be earned at the time that you receive them. That is absolutely permissible. It is recognized. It is universally used. But your contract needs to say that. It needs to say that the flat fee, okay, first off, we've made one assumption. You have a contract, right? You have a contract. I've been preaching this for 10 years. You have a contract. The contract says that the fee is earned upon receipt. Now, a contract does not have to be a long, involved thing. In fact, it can even be a letter to the client. That, in fact, can be your written fee agreement. It can be earned on receipt because you are making yourself available for that client at that time. And in our field, how many times is that like the biggest emergency in their life? So you're making yourself available. You're also foregoing other cases. That's the reason a fee can be earned on receipt in a criminal case, because you may be turning away other cases because you've got to take care of this case immediately. But do not then set it up to bill against it, to say, oh, well, here's my hourly rate and I'm going to bill against that amount that you made. Again, that's the trick, because then it's an advance fee and it has to go in a trust account. It cannot be, these are lots of nots in here, non-refundable if it's not earned. This is the biggest issue for the State Bar. They really hate that word, non-refundable retainer, because the whole deal about case law says a retainer is for future services. So how can you have a non-refundable retainer for future services? So the case law makes that really, really messy. They really, really hate that. They don't care if you say it's a non-refundable fee, non-refundable payment, but non-refundable retainer is like, you know, fingernails on the blackboard to them, because it doesn't make sense in their case law. The issue about this that makes it so difficult is the earned issue. Somebody comes in and pays a lawyer a large amount of money, flat fee, for a case. They go home, they think about it, they change their mind, and they want their money back. Has that lawyer earned that fee? Of course, the whole issue is going to be, what has he done? If the lawyer has immediately gone to the DA's office, and because of who the lawyer is and their reputation and their knowledge of the law, the DA dismissed the case, yeah, it's probably earned. But if the lawyer stuck it in his account and did nothing, and the client wants it back, it's probably not earned. So that's the big issue, is that that's always the issue, and it's drawing that line. If they want their money back within the first day, it's going to have to all be given back. The question is, they want their money back 6 months later, the lawyer will have earned that fee. So the issue on all the emails about the proposed rules were we were going to have to keep time cards, right, to prove that we earned it. That's just not correct. That is a non-correct statement. We keep files. We have our paperwork. We have our notes about what we did. We have our notes about our communications with our clients. That is proof that we earned it. The dismissal is proof that we earned it. You do not need timesheets to justify your fee. You can do it by the work that you did. But understand that clients have the absolute right to fire us, and they have the absolute right to ask for their money back if they feel it wasn't earned. The issue is whether the fee is unconscionable or illegal according to the rules. In the rules about fees, it says that the fee must not be unreasonable or illegal. So there's a lot of things that go into the discussion about what a reasonable fee is. It's the time and labor, maybe the novelty of the question and the difficulty of the issues, how much research the lawyer is going to have to do, is there case law on point or not, the likelihood that if it's apparent to the client that the employment is going to stop the lawyer from taking other cases. I bet every one of us has had that client call us and say, I'm going into the military, I'm moving out of the country, I have a job out of state, I need this case taken care of yesterday. Obviously, if you take the case, you are dropping everything else that you do in order to take this employment, and that justifies the reasonableness of the flat fee. Also, fees customarily charged. There is kind of a view of sort of what do people charge for these fees. The results obtained. The State Bar does look at the results obtained. There was one that we were wrestling with, was a capital murder case that got dismissed. And they wanted their money back. The case got dismissed, right? Mom and Dad wanted their money back. We were kind of like, that's really unusual. So the results obtained do matter. The time limitations imposed by the client. How quickly does the client need this done? And the nature and relationship that the lawyer has with the client. Have you represented this person before? What kind of relationship do you have goes into the fee. The experience and reputation and ability of the lawyer. Clearly, lawyers that have practiced longer, are board certified, have more of a reputation, are supposed to be able to charge more money, right? That's what it says. And whether the fee is fixed or contingent goes into the issue of reasonableness. I will tell you that having served as chair of this Commission for Lawyer Discipline for 5 years, we do not do fee disputes. The State Bar is not going to get into a grievance over a fee dispute. That the client says, well, it was really only worth $2,000 to get that DWI dismissed, and the lawyer made me pay $5,000. That is a fee dispute. And the Commission for Lawyer Discipline and the State Bar is not interested in prosecuting it. So how is this whole system set up? Texas is very unique, big surprise, about the way that we run our grievance system. We are all under the Supreme Court. The Supreme Court runs the State Bar, the Supreme Court supervises the grievance system. But the State Bar is set up separately because they cannot disband the Commission for Lawyer Discipline. There was some talk about that one time when they were going after a very prominent lawyer. So it is set up so that it is a committee of the State Bar, but the State Bar doesn't have any control because the Commission reports directly to the Supreme Court of Texas. There's a board of directors, and then under the Commission, all the Commission does is tell the prosecutors in the State Bar's office what they want them to do. We want the case dismissed. We want the case to go forward. We want this guy disbarred. We want this guy's case dismissed. That doesn't mean it's going to happen. That just is where they get their marching orders. From these 12 people, 6 are lawyers and 6 are non-lawyers. It's the only part of the grievance field that is split evenly with non-lawyers deciding how a grievance should go forward. Again, understanding why I can't explain to non-lawyers that we get to keep an unearned fee. That's the issue of it, is we have non-lawyers actively involved in our grievance system. Then under that, the lawyer has the choice between going to district court or the local grievance committees. On the grievance committee, there must be one non-lawyer for every 2 lawyers on the grievance committee. So again, there are lots of non-lawyer participation in the grievance section. This can all be found at texasbar.com if you want to see their latest annual report. I like to kind of give you the statistics. This is one of the reasons that I tell people not to become lawyers anymore. I didn't used to do that. We went in the 6 years that I was there from 60,000 lawyers to 87,000 lawyers are licensed in the state of Texas. Now, the State Bar receives, this has kind of stayed the same over the last 3 to 4 years, about 7,000 pieces of paper complaining about a lawyer. Only about 1,500, last year 1,700, actually stated a complaint. So over 5,000 complaints that were received by the State Bar were totally dismissed. They had a total of 371 sanctions with 28 disbarments. So I'm always asked, so why are so many of these grievances dismissed? Well, it's because it says this. This is what most of the grievances say. Yeah. I hate my lawyer. My favorite one is, I hate my wife's lawyer. Okay, I'm sorry. That doesn't really get us anywhere. It doesn't state a rule violation to simply say that you don't like lawyers, you don't think lawyers tell the truth, you don't think lawyers earn their money. It really, really doesn't state a violation of the rules, which is the only thing that the Commission for Lawyer Discipline and the State Bar can enforce, are the actual rules of professional conduct. So the biggest concern to criminal lawyers should be this statistic, which is above all of those things that are received, complaining. Compared to workers' comp, personal injury, family, there are twice as many complaints for criminal defense lawyers. And so that's a reason that we have to practice defensively. We have to practice understanding that today's client could be tomorrow's person at the grievance committee. So we've got to protect ourselves. So who can file a complaint? Clearly we all know that the client can file a complaint against a lawyer. A former client, a family member can file a complaint. That's the State Bar of Texas. If the State Bar of Texas receives information that a lawyer has violated the rules, and usually these are crimes, when the State Bar of Texas is notified that a lawyer's been convicted of a crime, they will initiate the grievance process. Judges file complaints on lawyers and are able to file them, and so you've got it. Anyone can file a complaint. I can't tell you how many answers that we saw from lawyers saying, I don't have to answer this grievance, this isn't my client. Okay, you have to answer the grievance. It states that you violated the rules. We need to know your answer to this. Under the language of the State Bar, they're considered a complainant and the lawyer is considered the respondent. So what's the number one complaint? It's neglect. Frequently failing to carry out an obligation owed to a client. This is the number one complaint. I paid my lawyer $5,000, he never showed up for court. That's going to state a rule violation, right? It states that he neglected the case, he didn't show up to court when the case was called, and so it states a rule violation, and the lawyer will be notified that they have to respond to that. But what is neglect? As we know, anybody can file, but neglect is specifically not good. Good faith is not neglect. Case law says an unskilled act or omission is not neglect. So if somebody hires a civil attorney to handle a criminal case and they don't do a good job, but they are there and they take care of the case, that is not going to be neglect. It might be malpractice because they gave bad legal advice. Just plead to this back time on the DWI and there won't be any other issues. And then we all know the $3,000 surcharge comes and the driver's license is suspended. And the client's going, I knew nothing of this. Might be malpractice, but in fact it's not neglect. The State Bar is not going to prosecute that lawyer for neglect because he didn't neglect the case. Same issue with ineffective assistance of counsel. Big issue in capital murder cases. The trial lawyer's not investigating the mental health and background of the defendant. They may have worked their tail off, found all kinds of factual witnesses, had tons of hearings and motions, but they may end up being found ineffective on appeal because there were all this psychiatric stuff when he was in elementary school that they didn't know about, that they didn't find. There's lots of cases on that being ineffective, but that is not going to be neglect. We had big issues with this because of the lawyers in Houston that were copying the inmates' writs and filing them as their writs of habeas corpus. It was absolutely horrible, absolutely horrible. Some of it was in almost crayon. And this was a lawyer saying it was his work for filing this writ. And as all of y'all know, you get one bite at the apple on the writ. And if it's bad, that client's never going to have their issues heard. It was horrible. We were all grossly offended. It didn't fit in neglect. And so as a result, we have the Capital Defense Writs Office to handle those cases now. The second complaint is failure to communicate. What we have here is a failure to communicate. Now this one, Rule 1.03, requires that the lawyer keep the client reasonably informed. And so this is the one where you can say, I don't have to respond to mom, girlfriend, and wife, right? I've had those circumstances. It is the client that you're required to keep informed. A big issue is what happens when you're fired. And under the case law in Texas, the file belongs to the client. I didn't know this until I started doing this work. I did the work. I created it. It's all my work product. Isn't it my work product? And the answer is no. The client has paid for it. It's their file. If they ask for it back, you have to give it to them. There are big issues in civil cases about whether the lawyer can put a lien on the file in their contract. That's really considered overstepping. The Supreme Court really doesn't like that. But I've seen some district court judges uphold it. I'm not going to give you the file because you haven't paid the fee. You're really treading on thin water because the case law is very much in favor of the client, that the file belongs to the client. They ask for it, you have to give it to them. In our field, there's usually a file at the courthouse that's pretty easy to direct them to also, so that you can get them some of the other things that they need. But just remember, if you want a copy, you're making a copy for yourself. And there has been a lot of grievances filed about lawyers wanting $500 to copy the file. Withdrawing from representation is another big issue in our field. Yes, sir.
Just back to the last point.
Yes, sir. Right. In the felonies, we sign an agreement that we will not give out the offense report. I think that we cannot, and I think that you're covered because of that agreement. Same way with the family violence things. I think we're covered in refusing to give them that because they would not be able to get that from the courthouse file or any other way. And it is interfering with your ability to do your job in the future if they cut you off. They say, we found out you gave the offense report, we're not giving you another one, right? So I think you have the right to refuse to give them the offense report. There was a lot of discussion that the proposed rules would not allow us to withdraw from representation. We all know that we have to have the judge's approval to withdraw, right? We can't just quit working and say that we're not the lawyer. We have to go to court and get the court's permission. Rule 1.15C is the one that usually kicks us in the teeth if we're trying to withdraw on the day of a jury trial. It says, when ordered by the judge to do so, we will continue to represent them even though we have good cause for terminating our representation. This happens to us all the time, that we have to continue even though under the rules we have the right to withdraw because the judge has the right to say, no, you're still on the case. So I know this is the hot topic, is the duties of the prosecutors. There are actual rules that apply to prosecutors. Yes, that does happen. I have people calling me constantly asking, does the state bar do anything to prosecutors? And the one that I like to show them is Terry McUrchin. It was the prosecutor on the Tulia drug bust case. He was sanctioned and placed on probation, and that probated suspension of his bar license is on the website for everybody to see based on failing to turn over Brady in those Tulia drug bust case. So what does it say in the criminal cases? It says a prosecutor cannot prosecute a case that they don't believe they have probable cause to proceed. A really interesting one in smaller counties is prosecutors are not supposed to be involved in custodial interrogation. And a lot of times you will see them in counties, and now with all the videotapes, actually in the room. And they cannot do that under the rules until they've made sure that the client knows of their right to an attorney and has made reasonable efforts to help the client obtain one, or giving an opportunity to obtain one. So prosecutors are really treading on thin water to be involved in custodial interrogation. This is Mr. Nifon from the North Carolina Duke lacrosse case. He did not disclose that the DNA had come back exonerating all of the Duke lacrosse players until after his reelection. So the State Bar in North Carolina looked at their Brady, which it talks about that you have to timely disclose to the defense all evidence or information known to the prosecutor. That's the big line there, known to the prosecutor, that tends to negate the guilt of the defendant. He was disbarred and actually eventually imprisoned for what he did. Brady also goes to punishment. We all know that in connection with sentencing, if there's information that's unprivileged, mitigating information known to the prosecutor, except when the prosecutor is relieved of that duty by a protective order of the court. So this means they can go to the court and get a protective order, that they don't have to turn over certain information. But otherwise, if it is known to the prosecutors, that is always the game they play, right? The cops had it, I didn't see it, it wasn't in my file. That's not really flying with the public right now. I did have lots of people ask me if we were going to talk about the hot topic, and I've actually been called by the news media, and I don't want to comment on it because I want the State Bar to take action. The most difficult thing in these prosecutor cases is there is a 4-year statute of limitations. For all of y'all that know Anthony Graves and heard the man that was on death row for 12 years based on what the Fifth Circuit said was gross prosecutorial misconduct, it was much longer than the 4 years before anybody filed a grievance in that case. And it is 4 years from when it's learned, but understand that they've had a lot of this information for the last 25 years. The just issue was it Brady or not? And so that's what's going to be the hot topic. That's what everybody's going to be looking at. So misconduct by the prosecutors. Of course, this has come up in the Court of Criminal Appeals where there's been a mandamus to remove a prosecutor that represented the defendant on a prior DWI. Court of Criminal Appeals said the rules are not the basis for mandamus and you cannot remove elected DA. They said there's lots of other complaints that you can make, State Bar complaints, that complain on appeal, but you cannot remove the DA in those circumstances. Also, they've specifically said that violation of the professional rules is not a basis for excluding evidence. It is not a 3823 argument that, well, he violated these rules, so therefore this evidence should not be admissible. But what I think is a key big change that all of us need to be watching out for is what occurred in the 2007 legislature of passing Article 1.051 of the Code of Criminal Procedure. Across the state, in misdemeanor cases, prosecutors and judges were telling people, don't you want to represent yourself? Don't you want to take care of this case? And the legislatures specifically mandated that if it involves a case involving confinement, just where the potential is confinement, Class Bs or As, the attorney representing the state may not initiate this contact with the client and ask them to waive their right to counsel. This is incredibly important. This is a huge change if you have ever practiced in a small county. We here are much better in Travis County in getting court-appointed attorneys to misdemeanors. But across the state, that was not the case. And so the attorney for the state can be in very serious problems if they initiate the contact. It says that it can only occur after the client has been told of their right to a court-appointed attorney, told how to apply for a court-appointed attorney, Then if the court says, okay, you don't qualify, the court still must give that client an opportunity to retain private counsel, and then the client can waive their right to a lawyer. And you know, in small counties, the issue is, how fast can we do this? How fast can we get this guy to plead guilty and go on down the road? And that was what this was designed to do, was to stop that railroad of railroading people into representing themselves, waiving very valuable rights, and getting convictions on their records. The court has the same duty under 1.051. A judge cannot order a client to go talk to the state. They do this. They do it in Burnett County. I'm telling you, this happens day in and day out. You want to represent yourself, go talk to the state. That is strictly prohibited under the Code of Criminal Procedure. You have to give this person the information about getting a court-appointed attorney. The court has to tell them, you have the right to a court-appointed attorney. Here's how to apply for a court-appointed attorney. And then they have to tell them whether they've qualified or not. If they don't qualify, they have to give them the opportunity to go hire a lawyer, not do it all right now within 30 seconds. Yes, ma'am?
Is the bar inviting reports of these ongoing violations?
Yes, yes, yes. They are very much interested in these. And why is this important that these counties around here, all of us handling DWI seconds, DWI thirds, family violence enhanced, all these enhanced misdemeanors? Because that waiver is invalid. It is presumed invalid. I've got one from Collin County. The statute specifically says you must tell them that if they qualify, they will be entitled to a free court-appointed attorney. Collin County says you can apply for a court-appointed attorney and you will be required to repay the county for the cost of that court-appointed attorney. That's invalid. That's a gross violation of the Code of Criminal Procedure, and the waiver of attorney is presumed invalid. So we have got to be getting these judgments, we've got to be getting this paperwork from these small counties, and we, as their defense lawyers on the higher charges, have got to be fighting these waivers. The big case for judges was the Supreme Court case in Caperton v. Massey Coal. Massey Coal is a huge, powerful, rich coal company in West Virginia. And they got a $50 million judgment against them for the way that they ran their mines and the death of some miners. So while they're appealing it, they give $3 million to the guy who's running for Chief Justice of the West Virginia Supreme Court. He wins. The miners obviously immediately file a motion to recuse. He refuses to recuse himself, and guess what? They reverse the judgment. Big surprise, right? So it goes to the Supreme Court. It was the first time that the Supreme Court has ever said they would presume harm. Presume harm in a recusal because of the amount of money that was contributed. All of our judges are elected. All of our judges get contributions. The judges are really concerned about this and concerned about this case, because no longer do you have to prove all of those steps that you have to on a recusal. You can, under this Supreme Court case, there are some circumstances where prejudice is presumed. So the next big issue that the state bar deals with constantly is lawyers that are convicted of crimes. And 8.04 says a lawyer shall not be convicted of a serious crime. So, well, okay, so what's a serious crime? It is a felony involving moral turpitude, any theft, reckless misappropriation of money will get a lawyer's bar license. What we go around the state telling law students is that a Class C theft can get their law license jerked. So that it's very important to understand that that includes deferred adjudication on a Class C theft can cause somebody to lose their bar license. The serious crime on the felonies, it has to involve a felony involving moral turpitude. I just know lawyers wrote this, right? It's just so interesting that it has to have moral turpitude. And there's a case that they lost that found that possession of cocaine is not a crime of moral turpitude. So felony possession of cocaine, if you read this, felony DWI has no mens rea, right? There's no intentional or knowing part of the DWI. So a felony DWI would not cause a lawyer to lose their bar license. But the Supreme Court was specifically called on to ask if a lawyer has completed probation, can the state bar still disbar them? And they said yes. So the fact that they completed probation on one of these felonies that fit the felony of moral turpitude did not prohibit the state bar from actually disbarring this person who had received probation for a felony theft. The big issue these days has been Barratry. And I travel around the state giving this speech, and I have lots of people just ask me, well, what is it? What is Barratry? Because Barratry you can get disbarred for. It is in person or by telephone solicitation of a client. That means that I go up to a client outside these doors and say, I'm a lawyer, would you like my card? I'll represent you on this case. I have committed the crime of Barratry. I can be prosecuted for the crime and I can be disbarred. They recently added the telephone because they felt like there were lots of people being solicited by phone. But the most difficult thing is in enforcing this is the definition of solicit employment that's in the penal code. It says that the communication in person or by phone with a prospective client concerning a professional employment that neither the person or someone acting on their behalf has requested. And that's always the issue, right? It's a he said, she said. If the client goes up to the prospective client goes up and says, are you a lawyer and could you help me? That's not Barratry. But the lawyer going up or hanging around the jail, passing out cards, that's Barratry. Now everybody goes, but wait a minute. What about advertising? Okay. So you have, this is the definition of the crime, the in-person or by phone solicitation. But of course, the legislature wanted to include lots of other things in that. They included chiropractors, they included written letters and notifications, and they added the solicitation by phone in 2009 as a crime. And of course, immediately somebody in Houston filed a writ, right, or filed a mandamus to stop the enforcement of the written part of this, and as far as writing letters, because the Supreme Court has said that there is something called commercial free speech, that you have the right to commercial free speech. And the case that went up initially in the 70s about lawyers was a bankruptcy lawyer that was sending letters to people whose houses had been set up for notice for foreclosure. Well, those people need help. And his bankruptcy help can stop that foreclosure. And the Supreme Court said that those letters were legal. So the Fifth Circuit had looked at this section of the code and said, okay, now we're going to say it's unconstitutional as to chiropractors because they can solicit for themselves. But then there was an interesting criminal case that came out of this 3812 that said that the chiropractor could still be prosecuted for the crime if he was soliciting for the attorney. Now, it would have been okay if he's soliciting for himself, according to the Fifth Circuit, but when he's soliciting for the attorney. If you know anything about personal injury, this is a huge problem around the state. They say that at hospitals, when accidents happen, there's just hordes of people hanging around trying to solicit these injured people at the hospitals. And this was what this was designed to stop. But the original case, the Moore v. Morales, and the reason it was Morales was our Attorney General when this first case came down about the letters. Can lawyers write letters to prospective clients? And the district court in Houston granted the injunction to all the DAs across the state and against the Attorney General. in enforcing that section that says that lawyers cannot send letters because it violated the commercial free speech. But of course, just to really muddy the waters, they appealed part of it. And the part that they appealed had to do, again, with contacting accident victims within the 30 days of an accident. And in that time of appealing that to the Fifth Circuit, the Supreme Court has said, okay, we're going to protect accident victims. And people who are involved in accidents do not need immediate lawyer help and do not need to be contacted in writing by lawyers. So part of Moore v. Morales went to the Fifth Circuit and upheld the crime of Barratry, of sending letters within 30 days of an accident to an injured person. So what came of all of this at the last legislature? A new civil cause of action. You should have seen these people. It was the most bizarre group of people. It's Texas for Tort Reform with the Texas Trial Lawyers Association. These people hate each other with a passion. They're in favor of House Bill 890 because it creates a new fee forfeiture. If they can prove that someone got a case by Barratry and the client has the right to void the contract within 4 years, and the attorney can be sued to forfeit their fees. The attorney that sues them has to have reported them to the state bar. And you can also get treble damages for Barratry. So what the thought was is that all the civil lawyers are going to start enforcing the Barratry laws by trying to set aside these. And of course, my view of it is it's probably going to be the insurance companies, right, claiming that the lawyer got the case by Barratry and trying to forfeit their fee. The other thing you may have heard about is the $10,000 penalty. This is really interesting. It's also included in this bill because it doesn't have to be an actual client. The client doesn't actually have to have signed up with the lawyer that committed Barratry. It was $10,000 per instance if they could prove that the lawyer was engaging in Barratry. And boy, did the traffic ticket lawyers freak out because they mail out thousands of letters to traffic ticket people, and each one of those letters was going to be a $10,000 fine if they thought that this applied to them. So that's where everybody went back to the Morales case out of Houston that said, no, it's not Barratry when it involves a criminal case, because you just think about it on our end, our people need information sooner in that time period, just for one, on a DWI to try to save their license, right? They've only got 15 days to save their license. So there's a way for the criminal bar to show that there's a necessity that this person get information. But that was the big fear, was that traffic ticket lawyers were all going to get sued for $10,000 a whack for their letters, because there's an attorney in Houston that's advertising he wants to take these cases. Have you been solicited? Have you been the victim of Barratry? Come to me and I'll take the cases. Yes, sir.
How about, this recently happened to me at Baker Street Pub on South Lamar. The man in the bar asked me to call his friend for a recent personal injury, and I just always say, have him call me.
Right,
so
right,
even with,
right. No, I think you just have a real problem. You know, it's not... It may be that line. I think, Alberto, you and I were talking about, you know, the mom asks you to go see the client in jail. You know, it can be kind of a very gray line. But when I try to tell people, when it all goes bad, it's going to be bad for us. And so it's just probably better that the caller ID doesn't have our phone number on it, right, that we called them. Because the new calling is the same crime. It's a third-degree felony. So let's talk about this unique process that Texas has. The lawyer's entitled to written notice of any misconduct. That written notice has to include the particular rule violation. And the lawyer in the state of Texas is entitled to elect district court, that is, forego any grievance committee, go only to district court. And we are the only state in the United States that you can have a jury trial on your grievance. We fought very long and hard for that. Most of them go to the local grievance committee because it is the only place in which you can receive a private reprimand. If anything goes to district court, it's all public. Public reprimand's the lowest sanction. Everything's public that's filed in district court. So most people opt for the local grievance committee. So what's the biggest no-no is not responding to the grievance. Right, so this grievance comes in that says this person failed to communicate. This lawyer did not communicate. And the lawyer goes, I got a stack of communications here. I don't need to answer this grievance because it's not true. Well, now they have a second grievance, which is failing to respond to the grievance committee. It is a separate misconduct. And so then the lawyer finally wakes up and sends in all this stuff saying, yes, I did communicate, and here's my stack of pink slips that proves it, and I've made all these calls, and yes, that part's going to be dismissed, but they have the failure to respond. So this is the biggest mistake that lawyers make, is they don't respond. It says that you have to timely furnish the CDC, the district grievance committee, or any other information that you're required to provide them under the rules of disciplinary procedure. So it's very important to respond to the grievance. These measures are something that I am particularly proud of as being asked to come into this and do work with the grievance committees. Martha Dickey's big push was to get some rehabilitative measures in place. We've had 38 active cases where we actually have lawyers who recognize mental health, substance abuse, or alcoholism, and they're going through the process with getting some specialized treatment from the state bar. We've actually had 46 people graduate, and some of them are the most heart-wrenching stories that you've ever thought. We have people whose partners that they've been with for 30 years died, whose wives died, and just great lawyers kind of spin out of control. And this has been a wonderful effort that the bar has done to really reach out to lawyers. The other thing that they implemented was a grievance referral program, and this is for minor misconduct. As y'all can see, we get a lot of complaints of not returning phone calls. That is minor misconduct. If the lawyer hasn't had anything in 3 years, it doesn't allege theft. We cannot take anything in grievance referral that involves money or theft of money. We have to show that what is alleged doesn't cause any kind of substantial harm or prejudice to the public. Again, we're talking about stealing money. And the lawyer has to be willing to engage in the grievance referral program. Then what happens is they go through a program, usually with a mentor, usually with somebody who's trying to help them set their office up better, get them the mental health or substance abuse counseling that they need. And if they complete it, it's a year-long program, the grievance is dismissed. So even though this lawyer may have had we see a lot of people that are doing great for a while and then they have a glitch. And it's almost always something in their life, some horrible trauma. Lots of lawyers are getting sick and don't have health insurance, and so they don't return phone calls. Going through this program that the state bar has, yes, they could have been sanctioned. It could have gone on their bar website that they got a public reprimand for not returning phone calls, but instead of doing that, the bar has set up this whole separate procedure to try to get them some help and get the grievance dismissed so they will not show up. Yes, sir?
Betty, one of the things I've run into over the years, I've had a client with obviously badly in need of, alcohol, or often there's other things underlying it. And I'll try to get them in some kind of therapy or see a psychiatrist, psychologist. And if they're professionals, they hesitate to do that because they're worried that that would come up sometime in the future or could affect their employment, et cetera. When I'm looking at this program, what if somebody filed this grievance and the person completed this program? Is that something that could be acquired by open records?
No.
From the state bar?
No. All of the stuff through the grievance is not subject to open records, mainly because we're under the Supreme Court. And there's lots and lots of people that try, and there's but the Supreme Court has said over and over and over again, because we're under the Supreme Court, it is not subject to open records. Yes, sir?
Does the complainant also have to sign off on
No. This is just the lawyer being willing to do it. The complainant's going to be told what the lawyer has to do and what the lawyer has agreed to do, but they don't have to sign off and say, yes, we agree that they go through this program.
And there's nothing they can do about that?
Right. They can't stop it. Right. And the truth is that 8% of us are going to get a grievance. So how can we avoid this? Number one, I scream and holler and hop up and down, please get some kind of written contract. Communicate with clients and document it through bills or emails or just pink slips, whatever you have, document it. Return the file if you're fired. Keep your address current with the State Bar. This is very important. It is a new rule that you have to keep your address current. You can't move 5 times and not tell the State Bar. In criminal cases, it's better not to represent co-defendants because that will get you in trouble. And have a trust account if you're going to say that a fee is an advance fee for future work. Put that money into a trust account. Answer the grievance. We're all required to have this notice in our office. It states how to contact the State Bar, what the 1-800 number is. You can get these little flyers from the State Bar if you want. You can attach, I've seen people attach that grievance notice to their contract. It's sort of bizarre to me, but they do that. CAP is one of my favorite things that the State Bar has done, and I really want to encourage people to know what that is. That's a client assistance program. Before any grievance is filed, they will ask the complainant to please contact CAP and see if it can be mediated. Now, if it's theft or gross neglect, they're not going to take it. But failure to return a file, failure to answer phone calls, maybe a fee dispute that they want to get off to one of the local bar offices have fee disputes. If an attorney receives a call from CAP, from the State Bar Client Assistance Program, please take it. Please talk to these people. They are trying to stop a grievance from being filed. And 99% of the cases can resolve it. And the whole reason the bar created CAP is because it takes a year for a grievance to go through the system. So a client doesn't want to wait a year to get their file back. It made more sense. Can we get this resolved at the beginning and avoid the grievance process completely? There's a 1-800 ethics hotline that has added 2 new lawyers to be available 24 hours a day. They won't get back to you. They're not going to answer the phone. You have to leave the message. But they will get back to you within 24 hours with the answer for your ethics question. Law Office Management is also a program to help you set up your office, find out if there's something better that you could be doing, a better way you could have it run so as to not run afoul of the rules. And then my favorite is the Texas Lawyers Assistance Program. And this is a big one where I've been asked. If a lawyer asks for help, if a lawyer says, I'm having mental health issues, I'm having alcohol issues, I'm having drug issues, they can go to the Texas Lawyers Assistance Program and it absolutely will not be sent to the grievance system. They are completely separate. It is completely confidential, and during the 6 years that I was on the commission, we never ever heard anything of any time about what happened over at TLAP, is what it's called, Texas Lawyers Assistance. And a part of what Steve was pointing out was that many times when lawyers are in distress, they've lost their wife, they may have lost a partner, or a parent, or a child. We saw some people who just had horrible stories about what had happened to them and why their life was falling apart. And what they also usually have done is lost their health insurance. So the president of the State Bar from Austin at that time, Terry Tottingham, actually took $100,000 of State Bar money and set it aside for counseling for lawyers. There is money available through TLAP to get lawyers counseling. And that can be the biggest, most difficult step that we try to push a lawyer into, is to go to counseling. Their last statement is, oh, I just can't do it because I don't have the money. I don't have any health insurance. So contact these people. Many of you know Ann Foster, who worked up here for years, is the head of TLAP. They have lawyers all around the state who have been there, done that, and know exactly what people are going through. Because the truth is that we have outpaced dentists in the suicides. We all knew dentists wanted to kill themselves because they didn't get into medical school, right? We are now way past dentists in the number of lawyers who take their own life. And we, as the lawyers, have to do something about this. Martha Dickey created the greatest video that I have tortured a number of you with and made you watch, called Practicing Law from the Shadows of Depression. You can now click on it on the bar website. You don't have to go to a CLE. You don't have to be in public. You can sit at your computer and watch this incredibly well done video. You can try to get that lawyer you're worried about to sit at your office and watch this incredibly well done video about the stress of this profession and how stressful and how difficult it is. And when you add on top of that this economic time that we're in, we all need to watch this video. But we need to reach out to our friends who are hurting. We need to reach out to those people that we know need help, and we need them to understand that there is help and there is hope, but you've got to ask for it. So it's important to me, it's important to the state bar, and it will not get the person into the grievance program. Yes, sir.
Because of the tough economic times and tort reform,
Yes.
there's a lot of PI lawyers.
Yes, Mr. Ivy.
Who are practicing other areas of law,
Yes.
like immigration and family law.
Yes.
I thought that there was a provision in the code that prohibits a lawyer from representing somebody in an area in which they're not competent.
It's horribly written. It says that, and then it says, except if they're going to gain competency in the area, or if they associate someone with them who is competent in the area. And we all know Mr. Ivy was JP for years and years. He is perfectly competent in criminal cases. But you are exactly right. There are, and I talked to some immigration lawyers who said they have seen a huge influx of personal injury people trying to do immigration and just making a disaster of it. Family lawyers are seeing a huge number of criminal lawyers going over there trying to do family law and making a disaster of it. And of course, that's then where you get into that issue of, is malpractice a violation of the rules? Well, no, not really. Neglect is. Neglecting the case is.
Going into an area where they have...
Because it says that you, in fact, are going to gain competency, it's almost impossible. That was the issue with those really bad writs. Do you know that somebody that copied one of those writs from an inmate was a board-certified criminal lawyer? The issue was, he's board-certified. This is horrible, but he's board-certified in criminal law. It's very, very hard to prove. It's a malpractice issue. But it's very, and of course in our field, we all know that if the person pleads guilty, you can't sue them, they can't be sued for malpractice. So our field is very, very rampant for lawyers taking it and doing a bad job and really hurting people. Because I get the calls, how come I can't get this TDC sentence expunged? You just can't. I'm sorry. I don't know who led you to believe, but it's been more than 7 years. How many times do you hear that? I don't know where they got that. It's been more than 7 years, so I should be able to get it off my record. Yes, ma'am. No, we don't. We do know that there's not anything in specifics, nothing about it. There's some case law, talking about being able to be prepared and being able to use it. There's some case law on the criminal case side, but nothing from the civil side. I know. There's some places in Houston where they're making you sign a plea that says you can destroy all the biological matter so that they will not be able to test it later for DNA and prove that you're innocent. There are some horrible things going on out there. And part of our job is saying, hey, I'm not going to lose my bar license just because you people want to violate the rules. And I think that's what Jim Sawyer was telling me. His response to Williamson County is that he wants it on the record that they don't want to turn that over. He says they back down on him when he says that. Yes, sir.
Betty, and for everybody else here, I know y'all all get the same questions that I get about Williamson County and what's going on there. do some research over the weekend to check to see whether a group of us should join to file a grievance over that. I'll talk to you more about it on Tuesday at the ACBLA lunch, but I think it may be time for us to join together, stand up, file a grievance, and let the chips fall
Where they may. That's absolutely. And that was my last slide that I wanted y'all to know was where to get that grievance form. TexasBar.com. Hit print. It will print it out for you. And that's certainly something that lawyers have done in the past. Lawyers have done it all around the state. That's what the lawyers did for Sharon Keller. There was a huge number of lawyers that signed that grievance through the Judicial Conduct Commission against Judge Keller on closing the courthouse at 5 o'clock to a death penalty case. So this is where to find it. It has the explanation of the rules. It has the form that you can print. It's in Spanish. That was another thing that was a big deal during my term, was we actually got it in Spanish on the website. And more importantly, you can also see a lawyer's history. A lawyer's history with the state bar, their grievances, anything that was public will be on this website. And so it's important to know where that is.
Is there any risk that you would not recognize a grievance communication when you got it?
No, it comes by certified mail. Okay. Comes by certified mail. No, you'll see it. It comes by certified mail. Oh, I'm sorry. Yes, sir.
Here in Travis County, even if the judge orders the state to turn over Brady or Giglio evidence before the day of trial, if the state turns it over before the witness testifies, apparently that meets muster with the Court of Appeals. Whether or not that has anything to do with grievance or whatever, I don't know. But
it's very frustrating to not be able to prepare, to not be able to adequately investigate it, get your witnesses. A lot of it has to do with what the lawyer does at trial. You've got to ask for a continuance, and you've got to document on the record that you just got this, I need a continuance, I want this reset. If you don't do any of that,
Joe, right there, even when Joe does everything right, when that happens, it's still not reversible.
The Third Court of Appeals will find that it's harmless. We all know harmless error has sucked up everything. Yes, sir.
I'm going to jump backwards. But
Yes, sir.
I have done this for years, and I recommended it to other attorneys, and they did it. Since our trust balance gives money out of IOLTA
Yes.
for good causes, I have an earned retainer. I stick it in my trust account. I leave it there because I don't need all that money. The case is going to last a long time. It's an earned retainer. I may pull part of it out. Have I been violating the rules?
No, that's exactly how to do it. That's exactly what they wanted you to do. But they also want you to understand that if you are doing a traffic ticket, that you're only charging the person a couple of $100s for that day's traffic court appearance, you don't have to put that in the trust account. You're talking about that big aggravated sexual assault of a child fee that you've put in there because this case is probably going to take 3 years. Right? That's the last one I had. Took 3 years. Number one on Worcester's jury docket for 2 years. So that's what we're talking about. Those.
You embarrass me because I'll put a regular DWI fee in there and do it over a year.
And yep.
I was thinking, well, maybe that looks like it's an hourly rate or something.
No, that's absolutely fine. It's just that it's also fine to take it as a flat fee earned on receipt, as long as the client understands that. Okay. So I see that I have tortured y'all for over an hour, which is what they need in order to put this out. I think they're putting it on the website and out around the state so that they are now being very economically conscious of the Court of Criminal Appeals money for training lawyers around the state. But if there's anybody else that needs anything, I'll hang. Yes, Jody.
You're up in Judge Bass's court and seeing somebody just being hosed. Are you saying I can't walk up and offer to help them?
No, sir, you cannot. That is Barratry. That is the definition of Barratry.
Even if you don't charge?
No, it has to be for a financial gain. That is the way some people get around it. And that's kind of gone on in this courthouse with people saying, I'll try your case for free. But going up to it does say for financial gain. Okay? Thank y'all. I sure enjoyed it.